raises his or her hands to object to whatever that will is, that automatically means there's a contest there and somewhere a lawyer needs to be. Yes.
Some wills actually have contest clauses in there. It says if any of my heirs contest the will, then they're disinherited.
Can that stand up in court?
Sure.
It can.
You can always fight things in court. Doesn't mean you're going to win.
Right.
You might be spending a lot of money in legal fees, but the disinherit clause or the no contest clause, excuse me, is something that works.
Mm-hmm. The disinherit clause can work too.
Yeah. What do you want to tell them
well,
about that?
there's it's interesting. In Rhode Island, talk about children first. As long as you name and acknowledge all of your children, and then you want to disinherit all or some of them, you can do that.
As long as you state it explicitly, or if you just...
You have to state it explicitly, because if you don't, then they'll assume you forgot that child existed.
And on that basis, you can contest easily?
Correct. Yes.
Easily? Yes.
Yeah, because you have to prove that it was a knowing disinheritance done by the person who's doing it. So that requires the naming of the people so they can say, yep, I knew who they were, and I provided for them during my lifetime if that's the reason why, and they're not getting anything now.
How far does that go down? Is it just meaning that you have to acknowledge that your X number of children, or do you have to acknowledge every grandchild or niece and nephew? How, just the immediate?
Yeah, well, it
Just the
depends.
immediate.
Right, if you have children, then it's the children.
If it's not
Period.
the grandchildren.
Right.
What I like to do in my wills, if there is going to be a disinherit clause, I show some consideration. So even if they leave the person $100, at least there's some consideration for the disinheritance.
You could do that.
It's not necessary, but
Now,
I do that
It
anyway.
becomes now more interesting with the spouse, because can you disinherit a spouse? And the problem with doing that is you can, but there's an elective share that the spouse can take, a life estate interest in all the real estate that the husband owned at the time of his death. So you have to be careful on the wording and how you do it to disinherit the spouse.
Is that often challenged the minute it's listed?
Depends on what the spouse is getting, because he or she may not like what they get in the will, and so the spouse has what's called a right to waive the will. So within so much time, they have a right. If they don't exercise that, then the will goes forward.
They can elect to take their statutory rights, the life estate and so forth. Remember you said the term dowry and that, well, at one point in time this meant the spouse was entitled to 1/3 in some states of whatever real estate the husband owned at the time of his death. That was her dowry. Well, those were eliminated, but life estate rights were given to the spouse.
And without really delving into this in any depth, because I don't think we have time to do it, if if there is a pre-marital or a prenuptial agreement, does that impact on what happens with someone's will or estate? If there, as far as if there had been some mingling or commingling of assets, or however that's handled, how does that complicate the making of a will or an estate?
Well, first you have to look at the language of the prenuptial agreement. If there is a waiver of estates in the prenup, and there's a subsequent death with a will, and then the spouse would basically
One of the
interest.
things you want to put into that prenuptial agreement is that the spouse, she or he, waives interest in the other person's estate, including any statutory rights they may have.
What does that mean?
Meaning that they're not going to try to elect against the will. If they've been disinherited in the will,
waive the will.
And so they don't want to waive not getting anything or nothing in the will and take their statutory rights. In the prenuptial agreement, they agree, they contract not to elect to get that life estate share.
Even more complicated would be if husband and wife get divorced, and during their nisi period, which is the time between the date of the hearing and the date it's final, usually 90 days, what happens if the husband dies in that period of time?
Well, we've had those cases.
We actually have one right now.
That's an interesting move. What happens?
If there's a property settlement agreement, then again, there's case law that differs. If there's a property settlement agreement, most property settlement agreements provide that each spouse waives interest in the other's estate.
Right.
So you can look at that.
It's another contract.
It's a contract. Okay, you're still legally married, but...
Now, if that's not in place, no property settlement agreement, just a divorce, you're still the spouse.
You're still a spouse.
If someone is preparing a will or an estate must they bring their prenup to the lawyer who's
Well, we ask. That's the first thing we ask.
Sure.
Yeah, that's one of the first things.
Because you
if there
can't
is a
draft
prenup,
it
yeah.
correctly without knowing what
What else
that
was
calls
said.
for.
Good point for those who need to move ahead in that direction. And in the time that we have left, which is not much, those who have wealth, is it better if the next of kin dies this year? Apparently so. So do you want to address that a little bit?
Sure.
The laws are about to change.
I think we talked about this a little bit. Yeah, George Steinbrenner. If George Steinbrenner, well, he did die this year, and I don't think at this point now it's going to become retroactive that they're going to put some number in because the Senate and the House can't agree on anything right now. So any idea what his estate saved for his dying this year?
God only knows.
$500 million. Because of what tax bracket his estate would have been in and the fact that it's now unlimited. It was unbelievable. And there's a number of other stories like that. So not that we would encourage anybody to die this year, but it is a good year if you're ultra wealthy to pass. But your heirs will not get the benefit of that step up in basis we talked about. So when they sell the property, they're going to get taxed at a much larger percentage of because of the increase in value. But you know what? They're probably not going to complain either.
That's true.
Yeah.
Explain inheritance tax and estate tax and death tax. Clarify the terms?
Well,
Ask the tax man. He's
yeah,
better at it than I am.
It's not really a death tax. You don't pay a tax for dying. It's not like a collection fee.
It's referred to. Some of those are.
People do refer to
That's
it
why we're
as
asking
that.
you.
So it's not that. It's, in Rhode Island at least, an estate tax. When you call it an inheritance tax, that sort of implies the people receiving the money have to pay it. It's the estate that's supposed to pay it. So in Rhode Island, it's $850. So if you die and there's an estate that's above $850, you file a tax return and you pay on a percentage of the estate that's in excess of that value. It's an estate tax. So that's the proper term.
Good. When someone passes away, and I don't know if you specifically mentioned this, but when someone passes away and there are affairs to be handled, whether it was taxes or bills that need to be paid, does the person who's handling as the executor, do they need to open up a new account for that deceased and have a tax number and all the rest of that? Do they need to do that, or is it just something, if they could write out checks from the deceased's checkbook because
unless they're a beneficiary on the account,
right,
then they can't do it on a joint account or a joint account holder. But you can't open an estate checking account until the individual is appointed as the executor or the administrator.
And then you do get a tax ID number.
And then you get a tax ID number. I don't think you can open one without it anymore.
No, you need it.
If there's not an estate per se, but just someone passes away, is it still the same situation? You've gone to court, yes, you're the executor. Do you then need to open up a
No, I think if the only thing in the estate is just a house that needs to be probated, you don't have to, because there are no bills that have to be paid.
But if there were bills,
then you have to open up an account because you need a way of paying the bills. Now, if the bills could get paid out of a closing, you might not necessarily have to do that.
Does it make sense that someone has another option about putting their name on a checkbook so they avoid some of this issue about having to start a new account?
I'll tell you
is there
what
value
it
in that?
certainly does. It makes it easier to administer that time frame between the person dying and the estate being opened. So if you have a child, if it's an older person has a child they trust and they don't care about that, fine, do it. Otherwise not.
Thank you. The discussion of legal matters continues. I hope you'll join us.